Oh, really? Yes, yes.
I just sit right on there.
No, flowers. Yes, I pick up pieces.
I'm staying for an hour.
I mix them.
General time before the so yeah, of course. Right.
No, that was just because I wanted to.
Oh.
Yeah, it's not really hard. Yeah, I went to the gym. Oh, that's right. I had to do it all, photo, video. Saturn and but I have family that I've been there many times. I'm very
At the time, they spent a lot of money worked hard for that one.
I don't expect to walk into that.
Yeah. Well, in my case, we also shot on okay. But I'm playing around with the website. Yeah. Come to order, remain seated. Court's back in session. Mike, Rick. All right, let's get on the record, please, and state order for this time. Mel Dennis, President of the Senate. Council, want to state your appearances, please?
Daniel Garrison,
Stu Adelstein, Reagan Liberty, James Benjamin, Peter Alfonso, Mr. Dennis, and President Moore.
Good morning.
Good morning.
State your appearances.
Good morning, Your Honor. Stephen Cleaner and Nicole Blumen and Samantha Rosen on behalf of the city.
Where's Ms. Bradley?
Ms. Bradley,
She's not joining us today? She could be on a case as your anticipation.
yes, sir.
All right.
I'm not going to hold anything to the contrary.
I'm sorry?
I'm nothing to the contrary. Any process.
Thank you. So this is got a couple of motions. I guess there's two of them. The first one has to do with the squashing of the subpoena.
Your Honor, we filed our motion to recuse. You set it down for a hearing. We tried to subpoena witnesses for today's hearing. The state would not accept it with their rendition of what happened was close enough to what we believe happened. There was no objection to it. We did not get proper service. We couldn't. You set the hearing on Wednesday. We did everything that we could humanly do to get witnesses here today. We let the state know who those witnesses would be by the fact that the classic server just dropped off the envelope even though we couldn't get perfect service. So their motion to quash is probably well taken because we did not get proper service. But all we're trying to do is move this case along. All we're trying to do is have a hearing and have the witness before you. I probably need the help of this court to order the witnesses to show. I don't know what else to do.
Well, Your Honor, at this point, I don't know where there's any authority to even issue this, because they're supposed to comply with the discovery, won't even comply with the discovery. And if they feel they're not getting all the discovery that they need to come to the court and get the court to give them an order that they can get further discovery. And then they might be able to move into the realm of issuing subpoenas for trial, which is before the hearing for today. And that is, maybe I'm not having enough case, maybe that happens, but I don't believe that there's any motion made and that there is the act of justice requires further discovery to be granted by the court. So it's very scarred to begin with. I'm not sure where all that the scheme that wants to investigate is coming from. They've been given the basically know of the alleged Brady statement is this court and ask the court further discovery and let the court know they're not getting what they want before they can go ahead and issue subpoenas.
If you've been injured in a car accident, don't let the insurance company bully you. You need a real trial lawyer who fights back. You need attorney Jay Sanders.
That speedy trial is right, that we've just become aware of what we think is a major transgression by the lead officer in the case, that we have 4 different Brady notices that are all different, that this happened in October of 22, and the state attorney's office sat on it through a whole trial, and up till a couple weeks ago, when we received these Brady notices.
Can I just stop you for a second?
Sure.
In your response, this is the motion that Defendant Jamel Devins responded to the state's motion to quash subpoenas and or for protective order. Paragraph 4, you indicated here that counsel for the defendant believes that there is a probable cause that the witnesses under subpoena, the members of the state attorney's office and the elected state attorney to have committed obstruction of justice and attempted witness tampering and felony pursuant to FS 838.022 for misuse of public office due to their actions since October of 2020.
That's what it says, Your Honor.
That's right. Very serious allegation.
Very serious allegation, very serious, we believe, alleged conduct.
So I want to know what the good faith basis that you have is for to make that statement.
Filed in the court file is the deposition of Michelle Boutros, which chronologically testified to what happened since October of 22, and who was involved and who had knowledge of what happened after, on the very day this happened, Ms. Boutros went to Mr. Hillary and told him what Detective Moretti did. and went to administration, to Harold Pryor, and told him on that very day what happened. And they sat on him for 11 and a half months, where a whole trial took place, where hundreds of thousands of dollars in legal fees were spent without knowing this absolutely vital impeachment evidence that is clearly Brady for a year. So they had meetings about it, and we were trying to ferret out, because your Honor says, what's our good faith basis? What a career prosecutor in the public corruption unit of the state attorney's office testified to under oath. And number one, Miramar Police Department was made aware of it. Number two, the head elected state attorney was made aware of it. Number three, all of his minions that are involved in are subpoenaing them, we believe were made aware of it. And if you look at all that and track the statute we cited, the conduct that we believe happened, and we have to ferret it out with depositions that they're avoiding and everything because of a 5-day rule, is where we're going to be able to prove what our good faith basis is, because we have absolute good faith basis for it. Yeah, and we'll stand on that based on Michelle Boutros' statement under oath testifying about this.
Do you have anything other than that statement of Ms. Boutros in the deposition?
Not yet. That's why we want to take the discovery of these individuals. What else could I have? If they deep six this.
That's what I'm asking you.
No, Judge, that is the starting point of where we need to go. And in order to develop it at this very late date that we just found out about this activity, the only way to do it is to subpoena these witnesses that do not have work product protection. And they shouldn't have a 5-day rule protection. Let's ferret it out. Maybe there's an explanation. I couldn't, in my wildest dreams, think of what it could be. Maybe they should get their own lawyer. Maybe they should take the fifth. But we need to ferret it out, because what more should we have before Your Honor than a sworn testimony from a career prosecutor in the public corruption unit who testified to certain activities of not only herself, but Mr. Killen, Ms. Bradley, and everything else. And I do have other evidence. If you look at the four, how many, Bradley?
Over 3 in a row.
The 4 Brady notices, that they all contradict each other. And one of them was signed by Mr. Killen, who's not even the lawyer in this case. He's the public corruption prosecutor. And he's the testimony in the next one. What could be more compelling a good faith basis than to show the actual prosecutor on this case, the homicide prosecutor that tried the first case without telling us anything about Moretti, is now changing her story 3-4 times. But this happened in October 22, so that's additional good faith basis for us to find out how and why we believe there's probable cause to believe they violated the law. If you look at the statute, the specific paragraphs cover contact just like this, just like they used to try to allege that Mr. Devins did witness tampering. They did the same thing. And we're going to prove it by having these people testify. We'd like to take their depots. We filed papers to try to do that in the last couple of days after Your Honor said it, but we haven't yet. So we want to have them testify in court today.
But your motion indicates, or your response indicates, that the elected state attorney committed obstruction of justice, attempted witness tampering, and a felony pursuant to 838.
Absolutely.
State attorney.
Absolutely, the state attorney, the elected official, Harold Pryor, we have good faith belief that he sat on this.
Well, you have more than that. You're saying you have probable cause.
I think there may be probable cause based on.
I think there may be probable cause.
Judge, if you quibble over this, you can do that and do what you want.
This is a serious allegation.
This is a serious matter.
That's right.
This is an absolute serious matter
I agree
that everybody
100%
sat on
with that.
and hid under the carpet for a year.
I don't know that everybody did, but
You don't know? So why are you asking me why I'm doing it? Because we allege it and we need to ferret it out, Your Honor. And it is a serious, but because it's serious, you don't think that Mr. Deming sitting over there isn't thinking this is a serious matter where his life is on the line, or the state attorney's office?
serious charge too. I'm not minimizing.
It's not two, that's why we're here, Your Honor, with all due respect.
All due respect, it's a serious matter, but so is allegations about corruption in the state attorney's office at the highest point. And when I read Ms. Boutros' deposition, somebody provided it to me, I assume it was your office, I don't know if you did or not, who gave it to me, but somebody dropped a statement off. I thought Ms. Boutros, who I know for a long time, tried many cases with her, indicated that the state attorney's office told her to be honest, straightforward, tell the truth.
So why wouldn't you believe testimony like that that says that Mr. Pryor knew about it the day it happened and didn't do anything about it? There wasn't any investigation by the very unit that investigates stuff like this, like the public corruption unit, that Killoran sat on it because he knew about it the very day for over a year, watching a first-degree murder case be tried without even investigating further this allegation. You know, there's a lot of things that trained police officers can do and investigate things such as an allegation like this, and they did nothing. And we're gonna be able to, once we get them to testify, show that nothing was done. And they deep six this serious allegation in a first-degree murder case, and there's testimony when if they told her to tell the truth. And you know her for a long time, I know her for a long time. We've had battles in court against each other and walked out and shake each other's hand because she's a professional. And she testified that Harold Pryor, the elected state attorney, knew about this the very day it happened. And nothing ever was revealed about it until the last couple of weeks. If this court doesn't think that's important and isn't
I think it's very
possible.
important. I think everything in that deposition is important, but I also thought Ms. Boutros indicated that it wasn't the position of the state attorney's office or the Mr. Pryor or the individual supervisors to go ahead and review what was done by whoever's involved in a case that they anticipate and expect that the prosecutors handling is going to do whatever Brady notices are out.
Well, let's find out, Judge. That's why we're here.
Wasn't that in the deposition on mine? I mean, that's what she said, correct?
She said what office policy is.
Correct.
I thought that they were told they couldn't testify about, so they cherry pick and choose which office policy they'll reveal. But she indicated in the same depot, she was told not to talk about office policy, but she did. So we got to ferret this out. Whether or not, if that happens or not, when there is an allegation against the lead detective in a first-degree murder that he lied in front of a career prosecutor that's brought to the attention of the elected official, they can't hide under, oh, we don't review every Brady violation. This went all the way to the top of their office the day it happened, and they did nothing, I believe. And I believe that is violates that statute. And I believe that in and of itself, based on one person's sworn testimony, is probable cause. But, Your Honor, I believe, based on your body language, with your arms crossed and a scowl on your face, looking at us like we did something wrong, should be
I
much
think
more.
this is really serious.
This is so serious. Why do you think we're all here? Why do you think this has blown up like this? Not because we did something for a year. It's because the state attorney's office and Mr. Pryor, who directs the office, who was elected by the people of Broward County to do justice, not to win cases at all costs. We believe knew about it and participated in a conspiracy to hide it. And that's what we believe, and that's what we pled, and we stand behind our pleas.
Thank you. Where's Miss Brad? I don't understand why she's not here.
I believe she has a deposition on. Folks, this morning, she has a deposition this morning. And you don't have it scheduled, but you have things planned. It's not like you don't, I'm sure, have other matters that we have to handle.
This is an issue where the way I understand the theory of defendant's theory is that Ms. Bradley is going to become a witness in the case. That they believe that depending on what is said by Detective Moretti, that if there's evidence that based on a flip-flop in the Brady notices, if they come back and they want to use Ms. Bradley to impeach her, to impeach Mr. Detective Moretti during the trial, that they have good faith basis to call her as a witness in the case. So how am I supposed to let an assistant state attorney stay on the case if she's a possible witness?
You know, this is all moved way past the way normal Brady issues are handled, right? So if some Brady, possible, many Brady issues come to light, what happened? Well, if you don't know what it is, you just think that the defense just thinks that there's something out there that they don't know what it is, it falls back that the state has its obligation to notify a Brady if they feel it, and if they don't, and eventually it comes out that it really truly was Brady, and then you get out a new trial, or you order by the appellate court. This is in general. If, however, they've got more specific indication of what the Brady material could be, they can come to the court, give the material to the court to look it over in camera, make a decision as to whether there needs to be any further implementation.
Typically, what I do when I have a Brady, there's some issue about it, the prosecutor who's involved in it tells me, she comes in here, she's got an obligation of candor in the court, and I ask her a question, and she advises me as to what's going on and why there's a change, why something like that. But she's not here. This is her case. We spent 2-3 months trying the case originally. It came to a hung jury, but she's not here for this. I don't understand that. Forgive me, I don't understand it. It's her case. She's supposed to be here. These allegations are very serious, and they include allegations of her, and I don't see her in the courtroom.
Well, I can
Explain it.
the court wants her here as the lead counsel and on the case.
I would think she'd want to be here.
Pardon?
I would think she'd want to be here.
Well, having been issued subpoenas, I think there's more of a basic difference versus her just being here and versus the lead prosecutor.
How is it? How does it make it there? She's the one who signed 3 different Brady notices, and they're different. How is that she doesn't think she should be here for this hearing when they're asking to recuse her as well as your office from trying the case, and she's not here? Forgive me, I don't understand it. Why don't you find out where she's at? Make a phone call. We'll take a recess. Make a phone call, find out where she's at. I don't understand it.
They cry because it's scary. I still love you.
Thank you, sir.
You guys are early. One seat.
Yeah, okay. Do me a favor, give her my best.
But the only credit you work, so you don't have like what they are. My dad had so much damage to my shoulders and I had to pull up. Yeah. You're right. That's what I think. I would have to do business like that. Scary. Like I do business. So I've always Chill. Like, yeah, they're doing it. Like, also, like, basically, gets retired. So my reaction when I saw you the other day, I was like, elected teachers. Wow. That is more than you know, I usually, yeah, whether or not
Mike, you there? Yeah. All right, let's go on the record. Yeah, stay
Quiet, please.
Quiet, please. State attorney, as well as Bradley. Good morning. Sir. I would thought you'd been here, but regardless, I didn't want to go any further without you being here because it's all the stuff is about your credibility, your integrity, and everything else. So I thought you needed to be here.
Understood.
All right. So let's go forward with this hearing. You call witnesses.
Your Honor, we're willing to call witnesses.
Call your first witness.
I was hoping, first of all, I don't know if all my witnesses are here because I tried to subpoena witnesses, the state wouldn't accept it, so I don't know who's here as witnesses. I know right now that Ms. Boutros is sitting in the courtroom. I don't know if she's well enough or feels well enough to testify. I'm certainly hoping that she does for my purpose, but more for her purpose, that I hope she's really good. And if she is available, I'd like to call her as a witness.
Ms. Boutros, is
I'm
that why
okay.
you're here?
Yes, Your Honor.
Come on up. You okay?
I am. I'm okay. Thank you.
She's here. She's out there watching her. Defense, right, there's a pending motion to watch. Defense basically said they agree with the motion, that's the way I understood it, that they were served incorrectly. So the motion to watch is granted. Ms. Boutros, excuse me, Ms. Boutros is here, and my understanding she's willing to testify. So they want to put her on and call her as a witness, they can. All right?
Your Honor, I would just like to clarification. What we acknowledged was we could not get proper service because of the time.
If I misstated that, that's what I understood you said, that you wasn't following because it wasn't enough time.
Correct.
But you agreed with them that the idea was that the motion technically should be granted. That's the way I understood it.
We're on the same page, exactly, but the bottom line is we're going to need the court's assistance to get on the witnesses. We're going to complete this hearing.
Thank you. So, you want to swear in the witness, please?
We'd like to vote for the because Christine Bradley is one of the witnesses. So we got a problem. And
Then call her first.
I'd rather not, Your Honor.
we can't call it first because we have to establish certain things on the record before we call.
Your Honor, in fact, I was expecting to call her last.
Without her having the opportunity to hear the other witnesses, because we feel a credibility issue. And the rules provide that we're not to be.
The rules provide for what?
Another witness in proceeding should not be present when another witness testifies.
And Ms. Boutros, you step down, then you call Ms. Bradley first. You call her first.
Because we don't want to call her first because we have to establish.
I don't want to excuse Ms. Bradley. She's here. It's her integrity in question. She's the one that's on.
And you're giving the state by
I didn't hear that.
unfair,
I'm sorry. I didn't hear that.
you're giving the state an unfair advantage to have the subject matter of this proceeding here, testify first before we establish all of the other evidence from the other witnesses. And certain evidence from those witnesses will be absolute subject matter for the testimony of Ms. Bradley, because she's the one that is the subject matter. So if we do it in that order, then we're not going to be able to have all of the evidence that we believe shows why this prosecutor, Ms. Bradley, should be recused. So if we let her go first, then we can't adequately cross-examine her or represent Mr. Demings with adequacy because we don't have all of those things necessary. So in that, just in the very issue of order, prejudices the defendant and it gives the state an undue advantage. And, I don't want to go belabor the motion to quash, but we have evidence that Ms. Bradley told us she's not coordinating depositions and we have to subpoena the witnesses for a hearing on Friday. And this was offered when she knew already that Your Honor had set a motion for Friday, and it was less than 5 days, and then the same office comes in and says, oh, it's less than 5 days, you can't have everybody else. This is not the way to carry out justice. And having her testify first isn't right.
As far as the email you're talking about, that was a deposition, it was not the story. And, they were going just, no, we're not going to coordinate them, but we'll second that. We'll accept normal service. Bring them over in normal service, then it's within the time period. We're thinking, no one was ever saying we're not going to accept any of your subpoenas. And those quantities are deposition.
I'm not talking about that. I'm talking about counsel suggesting that Ms. Bradley should be waiting outside.
I don't think Ms. Bradley should testify. Ms. Bradley's not under subpoena. She should not be, no one should be allowed to go into work product or opinion evidence or her thinking on a case. I mean, I see absolutely no reason for her to be taking the stand as well.
We will not have, sorry, I didn't mean to interrupt you.
This is a discrete issue. It's not talking about her mental impressions or how she's going to try the case or anything like that. They're not going to work right. They're not going to ask questions regarding that. If you do, I'm sure you're going to object, and I'll sustain those objections. This is a discrete issue. It has to do with the notices that were sent.
But at this point, I think incorporating the part for the courts, and we're seeming to get to the whole Brady issue and skipping over everything else. The only thing on the docket for today was the disqualification of the state attorney's office and whether they have shown actual practice. And that motion should be, as I argued in the response that I filed, denied. That's what was on the docket for today. We haven't made it to Brady yet. We haven't made it whether or not what Ms. Bradley may have done or not done or disclosed or not disclosed. That's all pivoting off the Brady issue. And we're not ignoring, that's not on the docket, okay? And look, in those four
this is my concern. I don't disagree that prejudice has to be shown. I don't disagree. My understanding is, though, that in this case, the fundamental issue that is presented is whether or not Detective Moretti's credibility is questioned, and whether he says X, Y, or Z is the state, is the assistant state attorney going to be called as a witness to impeach something that Detective Moretti says. And if that's the case, and she's called as a witness, then it'd be in a very precarious position where she would be arguing credibility to a jury at the end of the case, and there would be actual prejudice.
I don't even think we're to the point where the defense would know whether they were calling her or not.
Well, they've said it. They've said it they've given a notice in witnesses. They called, they know, maybe I'm wrong. Now, so I thought you filed a notice.
Not only notice, we filed, we handed the office a subpoena for her, that they told us that administration instructed them not to accept any subpoenas from us. And that was 3 days ago.
They did not. Again, the attorney, the chief, the attorney, and
Bradley should have been in there.
I don't think we had a subpoena. I don't think whatever.
It's irrelevant because it's not a valid subpoena because we didn't have 5 days. We're going to go around in circles. The bottom line, Your Honor, is you have set a hearing for today. We want to go forward on this hearing, and obviously the state's doing everything they can not to go forward on any hearings. Ms. Bradley is here, Ms. Boutros is here, the other state attorneys are in the office. We can have this hearing if the court will just basically say, I set the hearing for today, I want these witnesses here, let's get on.
We'd like to call Mr. Keller in person. So, I mean, just like they found Ms. Bradley in a couple of minutes, let's let them come down and we'll ask them questions and then see where we are.
I did send her, you didn't, and we filed a motion to quash and Ryder and Paul. And I didn't.
Regardless, Ms. Bradley's here. I want to hear from her. She's the lead attorney in this case. She needs to be. All right. So, Ms. Bradley, what we're going to do is I want you to step outside. You just wait outside. They're invoking the rules of this procedure. I'm going to give them a little legal have to do what they have to say with the other witness or read the deposition of Ms. Boutros. I'm sure that you have a copy as well, Ms. Bradley. Ms. Boutros, before we get started, I wasn't aware that you were ill, and I apologize. Have a seat.
Thank you.
Raise your right hand, be sworn.
I do. Michelle Boutros, B-O-U-T-R-O-S.
Ms. Boutros.
Yes,
Where are you currently employed?
the Broward County State Attorney's Office
In what unit?
in the Public Corrections Unit.
Okay, and what is the public corruption unit?
We investigate public officials who are engaged in criminal conduct. We investigate law enforcement that are engaged in criminal conduct, which would be a public official.
And how about if somebody in your office is engaged in unlawful or suspected unlawful conduct? Do you investigate that, or is that sent to an outside agency?
That would be a decision that administration would need to make. We wouldn't be part of that decision. I would assume so, but I can't say for sure. You'd have to ask them.
Okay, how long have you been a state attorney?
20 years.
And what units have you been in?
I started off, as everyone did, in misdemeanor, and then I moved on to felony trial unit, and then I spent 8 years in the gun unit, and then I spent another 7 years in the gang unit, and then I was in case filing for about 6 months, and then I was moved to the public corrections unit.
Were you familiar with a prosecutor's Brady obligation?
Yes, I am.
Can you please explain what you believe in?
In my career, in my practice, I disclose anything that I feel that would cause a credibility issue for a witness, any witness. Credibility, exculpatory, anything that would benefit the defendant at trial, whether it's admissible or not, is a decision that the judges make, not me. We call it Brady, we call it a supplemental discovery. You can put it on a paper napkin, but my goal has always been to be transparent and to provide the defense with any information that they deem that they might need at trial.
Now, let's jump ahead. You were asked to take over a case and get involved in a tampering with a witness case?
Correct.
Okay. And who did that surround?
It surrounded Jamal Demons and his mother, and the allegation was that they were tampering with 2 witnesses by the name of Holmes and I can't remember the other name, but the mother and the ex-girlfriend and the mother of the ex-girlfriend of Mr. Demons.
And this was being investigated as a separate case, part of this murder case that you're here today testifying to? How was this determined?
Well, it began as a separate case that I was to investigate Miss King, who was Mr. Demon's mother, to kind of discover whether she was tampering with these two witnesses. The actual statement included things about this case and included questions by Detective Moretti about this case.
When you say this case, but
This,
the murder.
the homicide.
Okay, and the investigative subpoena that was sent out, there are no case numbers on that. It's just an investigative subpoena.
We have internal investigative numbers in our office. They are not case numbers. They are just investigation numbers.
Okay, so somebody who was sitting there, Mrs. King, would not know what case this was about, just know that they were sitting there to give an investigative subpoena.
Sustained.
Fair enough. What were you asked to do on this case?
I'm never asked to really do anything. I'm handed a scenario and I'm asked to investigate it. And then I make a determination as to the steps that I'm going to take to do the investigation.
And what steps did you determine to take?
I decided that the first thing that I was going to do was to see if Ms. King was represented by counsel, and she was, and I contacted Mr. Trackman, and I originally asked him if she would come in without a subpoena. I believe he required a subpoena, and at that point, the goal was to get these two witnesses, and we wanted the information. So I granted her immunity by giving her a subpoena and explained that to her at the beginning of the statement. So Mr. Trackman was aware of what the investigation was about prior to this statement on the 12th of October.
How did you get assigned this case?
Mr. Killeran assigns the cases. So he, in this situation, was contacted by Ms. Bradley, who asked him if our unit would investigate it. And this isn't normally something that we would investigate it for whatever reason. You'd have to ask him. It was accepted into our unit and assigned to me.
Okay. And the reason why your unit doesn't normally investigate this is this didn't deal with a public official.
Yeah, correct.
So this was out of the norm that.
Correct, but we do things out of, we're not exclusive to public officials. If there's special projects that need to be done, we will handle them. So it wasn't alarming that it was in our unit.
It was out of the norm. There are other times that you do things out of the norm.
Correct. And when I say out of the norm, I don't mean that there was anything negative about that. I just mean that there are instances, like with maybe attorneys, we investigate attorneys and they aren't public officials. So it's really just on a case-by-case basis, and Mr. Killer makes those decisions with Ms. Falk and Mr. Pryor, and I just get handed the file here, go ahead and investigate this case.
Okay, so you subpoenaed Ms. King for a investigative statement,
Correct.
and she and Mr. Trackman showed up.
Correct.
Where?
On the 7th floor of the state attorney's office.
Okay, and is it in a special room of any sort?
There's a hallway in, when you get off the elevators on the 7th floor, and there's bathrooms there, and right before you make the right to go towards the bathrooms, there's a very small conference room.
Okay, can you estimate the size of this room?
I'm not very good at estimating, but I would say it's like a 6x6 room, but it's a small room.
Okay. So, what happened in that room?
So the first thing that happened is Detective Moretti and I were sitting on one side of the table. Ms. King and Mr. Trackman were sitting on the other side of the table. When we initially began the statement,
Have you ever met Detective Moretti before?
I have not met him. Oh, excuse me, I met him the day before because we had a meeting about this case, but I hadn't worked cases with him in the past.
We had no ill will or goodwill or what at that point.
I had really no information at all other, than he was the detective that was investigating this tampering case, and no ill will, no history.
And I'm not looking at that. How about you, Ms. Bradley? Any problems with Ms. Bradley during the course of the 20 years you worked there?
No history with Ms. Bradley either. We've always been very cordial towards each other.
So let's go back. Now,
Okay.
you're there in this small room. What happened?
So initially, Sergeant from Broward Sheriff's Office, Sergeant Hendricks, who I do know, was standing in the room. I didn't really think very much about it. I had approved the search warrant the day before. I didn't speak with Detective Moretti about when he was going to serve the search warrant. He was there. I didn't really think about it, and we started the statement. And then at that point, Sergeant Hendricks left the room.
Okay.
Once he left the room, the questioning.
And
Sustain. Ask a question.
after he left the room, what happened?
After he left the room, the statement continued. Detective Moretti asked most of the questions during the
And
statement.
as you said, they were not all just focusing on tampering, a lot had to do with the murder case.
I remember at one point that we were talking and Ms. King asked Mr. Detective Moretti why he was asking questions about her son's case. And he said something like, well, they're related in some way. And I tried to explain to her that some of the questions that there's, they were intertwined just because of the nature of the charge. It wasn't that she was tampering on a separate case. The allegation was that she was tampering with witnesses on Mr. Demon's case. So during the questioning, at a certain point in a lull, Detective Moretti made a decision that I was unaware of at the time to serve the search warrant.
That wasn't in your thought process at all that was happening during the time?
It wasn't, but I didn't tell him not to. We just didn't discuss it. It wasn't something that came up. I approved the search warrant. I assumed he would serve it that night, the next day. I really hadn't thought about it.
And who was in the room at that time?
During the service of the search warrant, it was Mr. Trackman, Ms. King, Detective Moretti, and myself.
Okay. Anybody from BSO?
No.
Okay. You described the room as being 6 by 6. If there was a BSO deputy in that room, could anybody miss that person?
Yeah, the room is so small that you could practically touch the person standing at the door.
So anyhow, what happens when he starts the search warrant?
Ms. King reached into her purse and she was fumbling with her phone.
Did you know what she was doing?
It's a phone, so she has this phone. I couldn't tell you what type of phone she had. She was pressing buttons on it. And Detective Moretti was saying over and over again, don't turn off that phone, don't turn off that phone. I knew she was doing something on her phone. I just couldn't swear to exactly what it was that she was doing on the phone. It looked like she was turning off her phone or sending a message or doing something on it. I just couldn't tell. There was a scuffle going on.
Okay, and what did Detective Moretti do?
Detective Moretti physically took the phone from her.
Okay, now, there was no BSO deputy in the room, correct?
Correct.
And this was BSO jurisdiction, the courthouse, correct?
Correct.
Okay, so Detective Moretti did not have the authority to serve that search warrant, correct?
I would always recommend that if you're not in your jurisdiction, that there's case law that suggests that you should have somebody from the jurisdiction that you're serving a search warrant or an arrest warrant in. I haven't done that research for a long time. I just knew that it was probably not what he should have been doing without a BSO deputy there.
Okay, do you know if his actions, and I ask if you know, if his actions were lawful in taking that phone since he did not have the jurisdiction in this courthouse?
I can't reach that conclusion. I mean, I'm not a legal scholar. I would assume that if she had standing, if there were a case, that she would have grounds to file in good faith a motion to suppress. What a judge decided is up to the judge, not up to the state. So I would, if I had known about it, I would have said to him, you need to wait for BSO to get here. And it's always better to err on the side of caution than it is to create a situation.
So anyhow, he serves the search warrant, she's fumbling with buttons on the phone, you're not sure exactly what she's pushing, what happened?
So I'm mimicking Detective Moretti, and I'm trying to calm everybody down. So I was like, you really need to give over your phone. It looks like you're trying to turn off your phone. You need to, it's a search warrant, and Mr. Trackman was very upset. And he did tell her she needed to give up the phone, and eventually Detective Moretti got the phone from her. He got the phone from her physically. He physically took it out of her hand.
During that, her giving the phone or having it taken from her, did you hear any exclamation from her that indicated that she had been hurt?
It was a yelp. It was like a yelp. It was like I can't really describe it any other way, but there was physical contact between Detective Moretti and Miss King. And during that physical contact of him taking the phone, Miss King, she yelped.
The physical contact was instituted by Detective Moretti, correct?
Correct.
During that physical contact, did he come in contact with anybody else?
I think he brushed up against Mr. Trackman. He definitely bumped him or brushed him or something. That was unintentional, though. I don't believe he did that intentionally.
What happened after he got the phone?
After he got the phone, Mr. Trackman and Miss King were both very upset. Miss King needed to call her employer, she said, and she asked if she could please have her phone to call her employer. Detective Moretti would not allow her to have her phone. I said that she could use my phone, and I asked to get the number, but he couldn't get into the phone, and that wasn't going to work out. So I tried to talk to Detective Moretti in front of Mr. Trackman and Miss King to see how long it would take him to do what he needed to do with her phone. And I don't remember what his exact words were, but he suggested that he would get it back to her as soon as possible, maybe even that day.
Okay. Do you know if he gave it back to her that day?
He did not.
Okay. Do you understand? I don't believe it's ever been given back.
I understand because I read Mr. Trackman's motion to return property.
So after he says he'll be given back in the day, or maybe by the end of the day, what happens?
So at that point, I walk out. I can't recall if I called Mr. Killer in or I saw him in person because it was probably close to the lunch hour. And I told him, I said, listen, I said, I can't work with Detective Moretti anymore.
I think you jumped ahead.
I did.
Because something happened after they left, as far as another deputy coming back in.
Oh, I'm sorry. Yes. So Deputy Gorell came in. Okay.
Mr. Trackman and Miss King leave.
They leave the room.
Okay, what happens?
Once they leave the room, Deputy Gorell, who I didn't know his name, he came into the room, and Detective Moretti looked at him and said, "You need to." Deputy Moretti said Detective Moretti said to Deputy Morell, "You need to say you were here when I served that search warrant." And it was kind of like an awkward moment. Someone described it just kind of getting punched twice in the head. So there's a search warrant that gets served, and I'm like, what's going on? And then the next thing, he's asking this deputy to lie for him. And again, I'm like this isn't like, I'm in the twilight, so I'm like, this can't really be happening. Deputy Gorell didn't say anything of any substance. I think he said, "Is there anything I'm needed for anymore?" or something like that. I don't remember if he said anything at all. It was just a very awkward moment after Detective Moretti said that to me.
And you specifically remember what was said?
I vividly remember what was said, yes.
So after that was said, and after Gorell leaves, do you say anything to Moretti?
No, I don't say anything to Moretti. I leave the room, I'm done with the statement. As far as I'm concerned, I'm done investigating this case.
Why?
Because I don't work with detectives that solicit lies.
Okay, what did you do then?
I reported it immediately on that day
To whom?
to Mr. Killerman.
And Mr. Killerman is your immediate supervisor?
Correct.
And what happened then?
So the next day after I reported it, I asked Mr. Killoran, what did administration say about this?
The thing that has to do with the inner workings of the office. Hey, work products, they're not issues that should be allowed to.
Your Honor, this is not work, I'm not asking for opinions on how they're going to try a case or anything like this. I'm asking for factual things, what occurred. It has nothing to do with the preparation of the case. It is not work product that is protected.
Well, that's factual knowledge, and all that is protected at this point. Because at least, it's always credible, and anything in writing, any possible privilege for work product writing that available in case closed. All over. Oral testimony never is allowed for services for work product or the investigated, the inside workings of the office.
How is a complaint that an officer lied and what should be done as far as investigating an officer that lied? How is that work product in this case?
We're going back to Brady.
Anything else?
No. Your Honor, this is simply facts, and that is discovery. I'm not asking for their opinions, their theories, or anything like that. Just facts of what occurred.
Hold on. Hold on. Anything else?
I was going to say, this is what I was trying to put about earlier. So we're moving out of the realm of the motion we're here on today, on the office, into the Brady, version of the Brady hearing.
I want to know if you want any further argument on this issue right now.
On the issue of,
I
know.
Thank you. Objection sustained. Ask your next question.
Okay. So I'm correct, you spoke to Mr. Killoran. Mr. Killoran talked to administration. That's where we can sustain it, correct?
I sustained the last question, so you, I don't want to recap. You just ask your next question.
Do you know who Mr. Killoran spoke with?
Yes, he spoke with Mr. Pryor and Ms. Falk.
Okay. Did he relate to you that he had spoken with you?
Yes,
And did he relate to you that the substance of the conversation was what you had told him?
Sustained.
Well, I'm not offering this conclusion.
I sustain the objection. Ask your next question.
You told her.
what I did at that point when I hadn't heard anything, Mr. Killoran, is I called a meeting.
Okay.
I asked Chris to set up a meeting with Mr. Pryor and him and Ms. Falk.
Okay, when was this?
The meeting took place on October 18th, 2022. I apologize.
And the event that occurred as far as the lying and whatnot, that was on the 12th.
Correct, October 12th, 2022.
Walking week or so later.
It was a Monday or two, yeah.
So you set up the meeting.
I asked for a meeting. I don't set it up. I say, Chris, I need to speak to administration about this. Can you please set up a meeting?
And was the meeting set up?
It was.
And were you able to speak to whom that day?
I spoke to Ms. Falk, Mr. Pryor, and Mr. Killoran.
And you told them what you told the board.
We're going to say earlier that now we're starting to get into the investigators, the inner portions of the office, and also it's a leading question. And one is going right into that area where now we're going to turn to work product, investigated information. That is why the case law that there's in the motion today. after you get in there, why they do what they do, what kind of investigations they do, and the court has said, and in the case of in the motion they even, it's not permissible.
Thank you. My understanding, counsel, is that Ms. Boutros was deposed. There was no objection by the state attorney's office as to her deposition being taken. There was no issue, any work product issue as to Ms. Boutros had been waived. She was presented for a deposition, and she had an attorney there with her. Ms. Huckle was there for the deposition, and she answered questions. There was no objection at the time. This is just an extension of that. As far as what she did, and when I say she, I'm talking about Ms. Boutros, what she did or she said, the objection notice overruled. She can answer that question. Not so much what Mr. Killoran did or said, or not what Mr. Pryor may have done or said, but as to what you did and what you said, I'm overruled the objection.
So if we're on the 20th and you're having this meeting,
Yes,
okay, and at this meeting, did you voice again what occurred in front of you?
I described exactly what happened as I described it today.
Okay, and without going into what was said to you, when you got done with the meeting, did you have an impression of what was going to occur?
No, I didn't have an impression until probably 2 days later.
Okay, what happened 2 days later?
I learned that Ms. Bradley told administration and already told her that he was joking when he said what he said.
Sustained.
You heard that Ms. Bradley gave another statement to administration.
I heard,
You
correct.
I sustain that objection. Ask the next question.
I did not ask what the substance of it was.
I sustain the objection. Ask the next question.
What did you do next?
I didn't do anything next. After I had the meeting with Mr. Killoran and he relayed to me what he relayed to me about what Ms. Bradley had told administration, my assumption was that it was handled.
Okay, and this was when?
This was probably the same week.
So we're talking October, maybe towards the beginning of November, whatever, but October probably of 2020.
It was just a few days before he told me.
And that was the end of your involvement?
Correct. Until
when?
I believe it was the defense filed a motion trying to compel my name and I'm sorry.
I didn't hear that. I'm sorry.
I apologize. I misspoke anyway. The next thing that happened was that I got a message that Internal Affairs in Miramar wanted to take my statement.
Okay. And what did you do when you got that message?
I called Mr. Killoran. I said, I got a request to give a statement to Internal Affairs. Please ask Mr. Pryor if I'm permitted to do so. And I subsequently gave the statement to IA.
Okay. And then what happened next for your involvement?
I gave my statement to IA, and nothing really happened until the defense filed a motion. I believe it was the motion to compel my name and the investigation. And if I could refer to my notes.
No, that's going to help you refresh your recollection.
Yes.
Go ahead.
Okay.
Yeah. Counselor, you want to restate your question? Refresh your recollection.
Sometime prior to November 18th, maybe a few days before, and I don't have pleadings in front of me, I learned that there was a motion to compel my name. I revisited this conversation with Mr. Killer, and I'm like, well, what happened with that? And he didn't know. I'm like, talk to administration, what happened with that? And I'm kind of a pest, so I kind of kept on it. And then there was a hearing on September 15th of 2023, and I saw Ms. Bradley announce on the record that the IA investigation had been closed.
You know it had been closed.
I did not know.
Okay.
Again, I gave my statement and I was kind of done. So I was out of it.
Okay. And when you heard that, what did that cause you to do?
I kept bringing it up to Mr. Killer, and I was a pest about it. Like, is there a notice? I kept checking on safes like 100 times to see if a notice had been filed, because we did have a meeting after it was closed, again, with Mr. Pryor, Mr. Killer, and myself. Ms. Falk wasn't present at that meeting. And during that meeting, I said, I really feel, and Mr. Pryor agreed with me.
Sustain.
You wrote that it needed to be disclosed.
Yes,
And this is after you got the word that the IA had completed, which was sometime in July of 2023. So this puts us more.
Sustain. Council, just ask a question, all right?
When was this?
this was on the meeting was on the 18th. No. It was on the 18th of September 2023.
Okay.
I had began at that before then, kind of looking into
Sustain.
it.
There's no question pending. Ask your next question.
The meeting, did you do anything before that meeting?
I learned that a video was pulled from BSO and given to Internal Affairs. And I learned that Ms. Bradley called Internal Affairs.
Sustain.
Okay, I'm not gonna ask you what Ms. Bradley's.
Okay.
So you learned that. What did you do next?
Well, that's when I started bringing it up again. I started bringing up, what's going on with this case? What's going on with, who knows about what happened with Detective Moretti,
Okay, and who were you bringing this up with?
Mr. Killeran.
And were you getting answers or did you not know?
He was trying,
Sustain.
I was asking Mr. Killeran,
Excuse me. I sustain the objection. Ask another question.
What else did you say to Mr. Killer?
that I wanted to have another meeting with administration.
And was that arranged?
That was the meeting on September 18th, 2023.
And at that meeting, you said,
I said, this is what happened again. And I said, you were told this by Ms. Bradley back in October of 2022.
Excuse me, what's the objection?
Here's it, she's saying it's Bradley.
Thank you. Any objection overruled? You can proceed.
I reminded Mr. Pryor that this had happened, that she had explained that Moretti said it, but he was joking back in October of 2022. And at that point, we all agreed there was going to be a notice.
you reminded Mr. Pryor.
Yes. Not that he had forgotten, I was like, this is what was said. He said it, and Christine said he said it, but he was joking.
Okay. As far as this joking, obviously, you don't know exactly what was in the mind of Detective Moretti.
No.
When he said it.
I do not.
But were there any overt signs that you saw of joking? I mean, he laughed, he chuckled, he winked, or anything? No.
No.
You took it as a true statement.
Correct.
So after this meeting, were you reminded, Mr. Pryor, of the meeting a year or so earlier, what happened then, as far as your involvement?
Having Granger as a partner, they make it very easy for us to keep our events safe.
Were you present at the meeting?
I was not.
All right, so I wanted you to talk about what you did, what's your involvement. I don't want you to go forward with other things, all right?
Did something happen, or did you do something after they had?
Mr. Killeran drafted a draft of a Brady notice after that meeting.
Okay. Did you see see that draft?
I did, it was sent to me via email.
Okay. And what happened with that draft?
That draft was not filed.
Let me ask you this, why would, and the head of the Public Corruptions Unit be filing a Brady notice in this murder case?
Objection, Your Honor. Again, she can't speak for what Mr. Pilgrim was doing, and why he was doing it. Also, there you go again, we're going to the issue of office policy.
Thank you. The objection sustained. Continue.
The draft,
Yes.
may I refer to my notes?
It's going to refresh your recollection.
September 20th of 2023, Mr. Pillorin sent me a draft of the proposed Brady notice that was to be signed by Christine Bradley with her name on it.
Okay, and what happened with that Brady?
Mr. Pillorin delivered it to Ms. Bradley's secretary, Anna, and she was told to sign it and file it, and it was not.
She being Ms. Bradley.
Correct.
Did Ms. Bradley sign it and file it?
No.
What happened with that?
Nothing happened with that notice. No notice was filed at that time.
What happened next?
The next thing that happened was that a Brady notice was filed. And I'm sorry. The next thing that happened is Mr. Benjamin called me. And that was on Friday. May I refresh my recollection with my notes?
Yes, you may.
(9/22/23).
And without going into what Mr. Benjamin said to you, what did you do in relation to that?
I asked for permission to speak with Mr. Benjamin. I sent a text message to Mr. Pryor and to Mr. Pillorin. And then Mr. Pillorin called me.
Objection. You know what they said, what they texted back. Only what you do.
Thank you. I sustained the objection. I don't want to know what you were advised by the administration, but as far as what you did or what happened next that you were involved with, you're more than welcome to answer.
Upon Mr. Pillorin returning my phone call, I returned Mr. Benjamin's phone call, and I discussed with him what had happened on the October 12th statement and everything thereafter.
What did you tell Mr. Benjamin?
I told Mr. Benjamin about the incident on the 12th. I told Mr. Benjamin about the discussions related to whether Moretti said it was joking. I told Mr. Benjamin that Ms. Bradley had said to administration.
She did say that she told me that. All I believe.
Thank you. Objection, no, it's overruled. You can answer the question. This is what you said or did. Go ahead.
I told Mr. Benjamin that I had reported it to Mr. Pillorin, that he had reported it to administration, that administration had called in Ms. Bradley, that Ms. Bradley said that Moretti said it, but he was joking. I told Mr. Benjamin that a motion to return the phone had been filed in November of 22 and heard in December or February of 23. Then I told him that I saw the hearing where the IA investigation had been closed. I told him that a video had been pulled and discussions had been had with Internal Affairs, with Miss Bradley and Sergeant Brittany Parker that I heard, and that I don't know for a fact. I told him that administration brought Miss Bradley in again and asked her again.
Is it what you're out? We're going to have here today by meeting our last week. The same, just giving out here.
Your Honor, may I respond?
What?
Your Honor, I've been listening to these objections, and I've done my best to abide by these court's rulings. I think I have. But we're losing track of where we're going. And the bottom line of this is through our motions, we are not only accusing Ms. Bradley of needing to be recused, but the entire state attorney's office needs to be recused. And part of that is to show institutional prejudice or institutional action. So the things that you have not permitted us to go into as to what did the administration do and whatnot, that goes directly to whether or not we have the administration, the state attorney's office actively involved in suppressing this information or turning a blind eye on it to allow Ms. Bradley to get away with Brady violations and violations of my client's 14th Amendment rights and 6th Amendment rights. And we're losing sight of that. We have the right to go into what did administration know, what did they say, when did they know it, when did they say it, and what did they do? That's the only way that we can show institutional prejudice.
Thank you. Counsel, the objection was pending as to what she advised in this conversation with your co-counsel, Mr. Benjamin, and that objection's overruled. Proceed.
Did you tell Mr. Benjamin about the various meetings that had taken place as far as with you and members of administration?
I did. There were several discussions between me and Mr. Killeran. I explained to him that I had spoken to Mr. Killeran about whether a notice had been sent. I explained that I had spoken to our appellate division, that that you wanted to depose me, and that we had further discussed whether this needed to be disclosed. I explained that Mr. Pryor and Ms. Falk summoned Ms. Bradley to come into their office. They, with Mr. Killeran and Mr. Pryor, specifically asked her again, who told you that Moretti was joking?
My objection, I was also when counsel was talking about institutional knowledge, none of that in his motion we are hearing today. He is on outside four corners of the motion they filed, which you are hearing today. It is completely insufficient. The hearing, I have a hearing end, and they need to file that amended motion, so the state not being any question about this line. Their mention today is totally insufficient. It doesn't meet any requirements necessary to refuse the office. If they want to file an amended motion, so the state's not ambushed, and then continue the hearing, that would be the proper way. Totally do not have problem ambush.
Counsel, my understanding is that the state attorney's office allowed Ms. Kutro to give a deposition. She was deposed on those matters, and it was discussed. There's no claim of privilege or work product or anything like that, because she's testified it. And the way I understood the deposition, she testified it with the knowledge and consent of the administration that she was permitted to do that. So your objection noted is overruled. Counsel, you may proceed.
I was just finishing up with what else you would have told Mr. Benjamin.
So I went through my notes basically.
Excuse me, Mr. Trackman, I don't know what you're doing here. I don't know if you're a witness in this case, but they've asked to have the rule of sequestration imposed. I don't know if you're a witness. If you are, you need to step outside.
We will not be called in.
My understanding was, Your Honor, that I was not listed as a witness.
Thank you, sir.
Thank you, Your Honor.
That's okay.
I think I had a question that you're about to answer, not my question, but
So I basically went through the sequence of events with Mr. Benjamin. So the last thing I was telling you is that Mr. Pryor asked Mr. Benjamin.
Excuse me, I don't want to know what Mr. Pryor asked Mr. Benjamin unless this is
I
part of the
told-
conversation
it
that
was.
you advised Mr. Benjamin.
I told Mr. Benjamin that upon hearing what was going on, they resummoned Christine into the office and asked her again, who told you that Moretti said he was joking? And she said, Moretti did. And then I told Mr. Benjamin that later that day, that was at the time that, and I might be getting my dates mixed up, but that Christine sent a text message to Ms. Falk that stated that she never said.
I realize you're wrong. Yeah.
Thank you. Objections, no, it's over. Proceed.
She never said that it was Moretti, and I didn't see the text message, but I told him that she said that it was Burrell that said it.
okay, so if I'm understanding, you're telling Mr. Benjamin that originally she said it was Detective Moretti said it was a joke, and then she later on changed it with Deputy Burrell that said it was a joke.
Yes, I told Mr. Benjamin that she told administration and Mr. Killeran that it was Detective Moretti in September of 23. I told Mr. Benjamin that back in October of 22, she told administration that it was Moretti and that he was joking. I told Mr. Benjamin included that Ms. Bradley had said that it was Moretti and he was joking to my administration. After that, I don't think anything had happened after the conversation with Mr. Benjamin. The next thing that happened was that I received the Brady notice that Mr. Benjamin sent me on the 24th of September of 23.
Okay, are we up to where Mr. Deputy Burrell is mentioned? Or is
That's the
that-
first Brady notice that I received that Mr. Benjamin forwarded to me on Sunday, the 24th of September, 2023.
I need these marks.
I made that.
give the witnesses access.
Sure. Couldn't see what you had in your hand.
Thank you.
All set?
Yes, thank you.
Go ahead.
I think you were telling me that Mr. Benjamin sent you something.
Yes, he sent me an email on Sunday morning that included a copy of the Brady notice that had been filed.
What name was that Brady notice?
It was September 23rd, 2023.
This picture,
Yes,
you said that Mr. Benjamin sent you an email along with an attachment,
correct,
and that was on the morning of the 20th.
correct.
And with that attachment was a copy of a Brady notice.
Correct.
Let me show you what's been marked as Defense Exhibit G. For identification.
I recognize this.
You do, but you recognize this as.
It's a notice pursuant to Rule 3.220B4, signed by Christine Bradley on the 23rd of September, 2023.
Is that a copy of what Mr. Benjamin sent you?
I had to read it. Correct. This is what Mr. Benjamin sent me. Yes, it is.
Your Honor, at this time, I'd like to have this moved into evidence as Defense Exhibit 1.
Any objection? It'll be admitted. Want to give the clerk and you'll mark? No. Want to give it to the clerk and mark?
This Bishop's in Defense Exhibit 1, if you look at that, it states, the undersigned spoke with Detective already.
What's the objection?
These records are in the court file, they see inside.
Thank you. Objection noted. It's sustained. Counsel, we don't need to publish that. I've read it. I've got a copy of it. Proceed. Ask your next question.
Your Honor, then with all due respect to the court, can I assume that every exhibit that we have filed is now going to be considered as part of the record for this motion?
Whatever's admitted will be part of the record.
Well,
So far you've admitted, my understanding is one. Is that correct?
I'm right, but you're saying that you reviewed other stuff and that's.
No, I've reviewed the notices. All I'm saying is I've reviewed the Brady notice.
Okay. I can still ask the question related.
Sure you can.
Okay.
I just didn't want you to read the whole notice.
No, I'm reading the last line of it, actually. Okay. It says here, the undersigned spoke with Detective Moretti in regards to this incident, and Detective Moretti said he asked Deputy Goral if Deputy Goral was there when the phone was seized. Deputy Goral responded something to the effect of, I can be if you need me to be. Did that occur?
No, it did not.
Okay. And as far as Detective Moretti asking if Deputy Goral, if he was there when the phone was seized, the room, as you said, was small enough that he would know that he was there or not, correct?
I can't testify as to what Detective Moretti knew, but it would, in my opinion, it would be impossible not to know if somebody was in that room.
Well, you'd expect the lead investigator on the first-degree murder case to be able to see who's in room of 616.
Don't argue with the witness, counsel. Counsel, Sustained. Don't argue with me.
Okay, so that was, Mr. Benjamin, did you talk about this after?
I responded to Mr. Benjamin and explained that that was not accurate. I actually blind copied Mr. Pryor, Ms. Falk, and Mr. Killeran on that email. And I reiterated what I told him during that conversation.
Okay, and you copied them.
I did.
Did they respond to you
No.
without saying what they responded?
They didn't.
What happened next as far as your involvement?
Can I look at my notes to refresh my recollection?
Still refresh your recollection she made.
I asked Mr. Killeran Monday morning, the 25th, or Tuesday morning, I think the 25th was a holiday.
So it was a Saturday.
It was,
22nd, you said it was a Friday, so that's right. The 23rd was on Saturday.
so I might be mixing up my dates. Maybe the 24th is when Mr. Benjamin sent me the email.
That'd be Sunday.
Okay, so he sent it to me on a Sunday, but Monday was a holiday, I believe, that Monday. Maybe it wasn't. I don't remember. I know the next thing that did was the beginning of that next week. I asked Mr. Killeran, what is this and why was this filed? Because no one had responded me to this Brady notice.
Whether we just walked in there.
Yes,
And you asked what this was.
yes. And I requested the emails that went back and forth that resulted in that Brady notice from the night of the 22nd of September, 2023. I requested on email.
Did you get that?
I did.
And did that explain to you how this notice went out?
No. The emails that I reviewed were directions that that should not be filed because it was inaccurate.
Now, she's no longer testifying what she told me. Now she's telling what the years it is inside.
Thank you. Objection sustained.
What happened next? What did you do?
I'm refreshing my recollection again. I received a call on 9/26/23 from Mr. Pryor.
Okay. And relating to this incident,
Correct.
what did you do in relation to that call? Did you meet with somebody?
No, I didn't. He just called me.
And you spoke about this without going into what
Correct.
said if this was discussed with Mr. Pryor?
That's correct.
Okay. What happened then?
They asked me to join a meeting with them at 3:30 p.m. on September 26th, 23.
Did you go to that meeting?
I did.
And what did you say at that meeting?
We just discussed that there was going to be a new Brady notice.
Sustained.
I was just asking what you said. If you don't remember specifically what you said, then
I asked if a new Brady notice was going to go out to correct the one that was sent out on the 24th or the 23rd of September.
I'm sorry, I'm not, that's your phone.
So I wanted there to be a correction to the Brady notice that was sent out by Ms. Bradley on the 23rd or the 24th of September.
That is what you voiced.
Yes.
And what occurred after?
They requested another meeting on the 27th of 2023 at 9 a.m. in the morning.
Were you there?
I was.
without going into what other people said, did you say anything?
Yes, I did. I suggested that Ms. Bradley probably shouldn't be calling me a liar in this situation because I had learned that she had done that the day before in front of a group of people in the office.
So you said you were lying.
Yes.
Anything else that you said that time?
No. I mean, other than there was a Brady notice in between that time. So there was a new Brady notice. We discussed that.
Is that the one that Mr. Killer said?
Yes, that was on the 26th of September, 2023.
I'm gonna have to drive you crazy today because I'm not this morning. On the 27th, whatever it was, you had a meeting, and in between that time, there had been another Brady notice sent out.
Correct.
Did you ever see that Brady?
I did.
And who signed that Brady notice?
Mr. Killeran.
Let me show you what has been marked as evidence exhibit F for identification.
Yes,
Do you recognize?
I recognize this. It's a Brady notice, an amended notice pursuant to Rule 3.220B4, signed by Mr. Killeran.
And is it an exact copy of what you had seen previously?
It is.
Your Honor, I'd like to move this into evidence.
Admitted. Present to the court, please. No marking.
It's, yeah. Now, in this notice, we're just the last paragraph. It says the lead ASA assigned to this matter relayed to SAO administrators that she spoke with Detective Moretti in regards to this incident, and Detective Moretti explained that his statement to Deputy Gorell was a joke. The lead ASA subsequently filed a Brady notice with the court on September 23rd, 2023, which stated that Detective Moretti told her that Detective Moretti asked Deputy Gorell if Deputy Gorell was there when the phone was seized, and Deputy Gorell responded something to the effect of, "I can be if you need to, if you need me to be." Again, that did not occur. Or,
Yes, before. Counsel, can you restate the date on that Brady notice, please?
the Brady notice is the 26th of September 2023.
Proceed.
Then the last part of that says, additionally, the lead ASA relayed to a state attorney office administrator that the deputy was the one trying to be funny. Was Deputy Gorell trying to be funny?
No.
Did you even hear him say anything that?
No.
Okay. Do you know if Deputy Gorell was ever contacted?
I don't know.
Would it be up to Ms. Bradley to contact Deputy Gorell?
I don't believe so. He's not a witness on her case.
Okay, so if she went out and she contacted Deputy Gorell to appear for Detective Moretti, that would not be office policy for her.
I don't really know.
What's the question? What's the objection? Sustained.
As a homicide prosecutor, would it be a homicide prosecutor's job to speak with a witness that deals with a tampering investigation as far as whether another witness lied.
I'm not really sure what you mean. Are you asking me if Miss Bradley would have normally contacted Detective or Deputy Gorell to see if?
Yes, is that normal?
I can't say that that's normal or not normal. I mean, that's a different crime, a different investigation.
What happened next?
You took my deposition on Friday of last week.
Well, did another Brady notice come out?
Oh, yes, I apologize. So the next thing that happened was that during that deposition that you took of me last Friday, you showed me a copy of the Brady notice that was filed on the 28th. I hadn't seen that prior to our deposition.
Okay. Were you expecting another Brady notice to be filed?
I was,
Okay, why is that?
because that's what I was told that was going to happen.
And
Against the wishes of the administration.
The state.
let me show you what has been marked as the fence page. Do you recognize this?
I do.
What is it?
It's a copy of a second amended notice pursuant to Rule 3.220 before signed by Ms. Bradley on the 28th day of September 2023.
And that had been presented to you prior to your deposition.
You know, you presented it to me during my deposition, or Mr. Benjamin did. Somebody presented it to me during my deposition.
And this is, and the testimony in your deposition reflects some of the things that are in this document.
Correct.
Your Honor, I'd like to move this to heaven.
Any objection? Go ahead, I'm sorry.
This is the third one.
It's admitted.
Each will be marked next to you. Now, in this one, I'll just read the last part of this. It says, the undersigned inaccurately relayed to the state attorney SAO administrators that she spoke with Detective Moretti regarding this incident, and that Detective Moretti explained that his statement to Deputy Gorell was a joke when she intended to relay that which is contained in the Brady notice filed on September 23rd, 2023. Additionally, the undersigned relayed to a state attorney administrator that the deputy was the one trying to be fired. Is this accurate, this Brady notice, as far as what you know of facts?
No, but I don't see that as a fact notice. It's her saying she accidentally said something.
This accidentally saying something, as far as Detective Moretti saying it was a joke or not saying it was a joke or whatever, how many times did you hear her say that she spoke to Detective Moretti?
Did I personally hear her say?
Yeah.
I didn't ever hear her personally say
So that
that.
was all through administration.
It was all through administration and through Mr. Killeren's Brady notice, and I heard it through Chris Killeren and Mr. Pryor, and that's how I heard it. I haven't spoken to Ms. Bradley about this case since October of 2022.
Did you do anything else in this case after you gave us the deposition?
No.
For 92 seconds to speak with that.
Yes.
Yeah, that big view. Yeah.
Just real briefly, I promise. You said that there were emails that were going back and forth through the office starting in July of 2020, October of 2022, dealing with this issue of Brady.
I don't know if there were emails that went back and forth between administration and Chris. I wouldn't know. I wouldn't have been included on those emails. There were emails that went on over the last month or so related to this issue, but I don't know what was sent back and forth.
How about text messages?
Not with me. I wasn't part of any of those text messages if they existed.
Thank you so much.
Thank you.
Any questions?
Very, very, very.
What? Well, I just want to clarify, I did on direct, you said that the investigation is still working on, the one where there was tracking and I believe for the month, correct?
Right.
Was completely separate from murder.
That's not what I testified to. It was supposed to be, but that's not how it turned out.
But was that evidence of murder or the murder trial? Evidence of the murder trial coming out of that investigation? Just the investigation of the investigation, why you searched this out.
So I think that I'm not understanding your question. I'm not trying to be evasive.
Restate your question.
Want to clarify the investigation for we're working on.
The tampering of Miss King, okay?
Part of the murder case, or was it separate?
Well, it would have been a separate charge because Miss King isn't a suspect or being accused of the homicide case, but the evidence itself could have been admitted if she and Mr. Demons had been tampering, if that's how Ms. Bradley had decided to try her case. It depends on the circumstances. That's a strategic decision, and I wouldn't be able to answer that question. If something came out of that deposition or that statement that somehow was describing that Miss King and Mr. Demons had paid one of the witnesses or something, I would assume it would be part of the murder trial to show that they were tampering and consciousness of guilt. But that again is, I'm not very familiar with all the facts and circumstances of the actual homicide, so I can't really answer that question. But I think I said that it was a separate crime. Is that what you're referring to? That's not what I was talking about when I said that.
And I've been reading so much, but it's also unclear about mentioned carefully, Mr. Travis now statement that Kevin Miller made to
I spoke to Mr. Trackman at the time. I don't remember everything I told him. I told him about the deputy not being in the room and that I thought that was an issue. I apologized to him for how everything went down. I don't know if I told him what Moretti's statement was because I had reported that to administration and to Chris. But I wanted to make sure he understood where I stood on the service of the search warrant. But I did speak with him.
It was short. Remember how long?
It must have been the same day, maybe the next day, but if this is back in October of 22. So I know that the first thing was to report it to my supervisors. The next thing was for me to report it to the attorney that I was working with that had his client's phone seized at the time. So that's correct.
Excuse. Thank you. You may sit down. You're excused.
Thank you.
It's now 12 o'clock. We'll see everybody back at, let's say, 1:15. All right? Thank you. Have a nice one.
May I be excused for the day, Your Honor?
Thank you. We'll talk about that Bradley is available, and who else you have available, or whatever witnesses you want. All right? Thank you. We're ready. Oh, no, I didn't. We got plenty of. Okay. So you don't have to get them going. You don't have to get them going out. We got plenty. Okay.
Longer than you guys anticipated.
Recording stopped.
Gary.
Okay, folks, court's over at 1:15.
I know I can.
Okay, yeah, I guess we gonna stop right here. I'm gonna go get me some medicine. We go get me some medicine. We gonna stop right here. If they come back out, I'll be back. Go to the store and get some medicine. That's it.